Subscribe to our channel and press the bell icon so that you never miss any video lesson from Rao's IAS Study Circle. Join the official Telegram channel of Rao's IAS Study Circle to stay updated and get all the materials on the Telegram. The link to the channel can be found in the description box. Hello and welcome to Daily News Simplified, an answer to what, why and how of newspaper reading from a UPSC examination perspective. So today let us discuss the important news which has appeared in the New Delhi edition of the Hindu newspaper dated 2nd April 2021. The news to be discussed has been displayed on your screen and timestamping for the same has been provided in the description box below. So on this note, let's start our today's discussion. Now let's take up this article appearing on page number 6. It says, an act of colorable legislation. Enactment of Places of Worship Act 1991 in its current format damages the liberty of belief, faith and worship to all. Now the Places of Worship Act 1991 prohibited conversion of any place of worship and also provided for the maintenance of the religious character of any place of worship as what existed on 15th August 1947. So basically this particular legislation prohibited conversion of religious places of worship as what existed on 15th August 1947 and also barred judicial review. So it is in this regard the authors in this article have stated that based on certain aspects of Places of Worship Act 1991, they have challenged this legislation in the Supreme Court of India as being ultra-vires or being unconstitutional on certain grounds. The authors in this article highlights that this legislation bars judicial review under Article 32 of the Constitution as well as under Article 226 of the Indian Constitution. And since it bars judicial review, hence it can be said that this aspect of this legislation is violative of the basic structured doctrine of the Indian Constitution as was established in Kesavananda Bharati judgment. Further, the authors in this article also highlights that the pith and substance of this particular legislation is ultra vires as it bars judicial review of the Supreme Court and High Courts. Further, the authors have also accused this legislation to be an act of colorable legislation. So this article appears in the context of another article which appeared few days back where the aspects of Places of Worship Act 1991 and Supreme Court judgment on Babri Masjid Ram Janmabhoomi case was discussed. Now in our previous DNS dated 14th March 2021, we have already discussed in detail about the Places of Worship Act 1991 and also the important provisions regarding this particular legislation. It says that section 3 and 4 of the Act declare that the religious character of a place of worship shall continue to be the same as it was on 15th August 1947. And it further says that no person shall convert any religious place of worship or any religious denomination into one of a different denomination or section. So basically, the authors in this article have challenged this particular legislation, namely the Places of Worship Special Provisions Act 1991 in the Supreme Court of India. So from our examination perspective, let us understand about the doctrine of pith and substance, the doctrine of colorable legislation, and also certain important facts with respect to the basic structure doctrine as questions can be framed in your prelims and also in the mains examination. So regarding the doctrine of pith and substance, pith means the true nature or essence of a legislation and substance means the most significant part of the legislation. So basically this doctrine is used to find out the true nature or essence of a particular legislation and not generally its impact or ancillary effect. Now mostly the doctrine of pith and substance is used with respect to Article 246 of the Indian Constitution which provides for 7th schedule. Now we all know that the 7th schedule provides for 3 lists, namely the union list whereby entries have been provided under which the central government can frame laws, state list under which the respective state governments can frame law and the concurrent list in which both central government and state government can frame laws or legislation. So at times what happens is that state under various entries of concurrent list ends up making a legislation which essentially comes within the jurisdiction of central government. So this particular doctrine, namely the doctrine of pith and substance, is applied to find out the true nature or the true substance of that particular legislation. That is why the particular legislation was enacted, that is for what purpose. And this doctrine does not essentially consider the ancillary effects or impact of the legislation. So this particular doctrine, namely Pith and substance, is applied to find out the true nature or true essence of a particular legislation. Now, the doctrine of Pith and substance was applied for the first time in the case of F.N. Balsara versus State of Bombay. Now, moving further to the doctrine of colorable legislation. Now, the very core principle of doctrine of colorable legislation is that what cannot be done directly also cannot be done indirectly. And effectively, it traces the competence of a particular legislature to enact a legislation. Now, from the perspective of Indian Constitution, again this competence of a legislature to enact any legislation on a subject matter can be deciphered under Schedule 7 of the Indian Constitution under Article 246. So it is here where the judiciary, under the doctrine of colorable legislation, finds out the competence of a legislature, whether the particular legislature was competent enough to enact a particular law. So effectively it says that doctrine limits the overstretching or misuse of constitutional power granted to the legislature. Now what happens at times is that in the guise of colorable legislation, states or even central government frames a law or enacts a law which it could not have enacted based on constitutional principles. And it was in the case of KG Gajapati Narayan Deo versus State of Orissa, the Supreme Court held that transgressions by any legislature can be either patent, manifest or direct, but can also or may be disguised, covert or indirect. And it is here where the Supreme Court held that the doctrine applies to the latter class of cases. That is where the legislature is not competent to make a law on a particular subject, and because of this has used certain disguised terms or has used certain indirect terms to enact that particular legislation. So basically the doctrine of colorable legislation finds out the competence of a particular legislature to enact a particular law. Now after understanding about doctrine of Pith and substance and also about doctrine of colorable legislation, let's learn certain basic facts with respect to the doctrine of basic structure. Now before understanding the doctrine of basic structure, there was a tiff going on between Parliament and judiciary. Now the Parliament wanted to expand its amending powers under Article 368 of the Indian Constitution, whereas various judgments of the Supreme Court overall tried to limit this power of the Parliament under Article 368. So it is based on this understanding, let's go through some of the important judgments which overall has shaped the doctrine of basic structure. So it all started with the Shankari Prasad judgment on First Amendment of the Indian Constitution, which added the 9th schedule to the Indian Constitution. Now Supreme Court in this judgment upheld the validity of Constitution First Amendment and held that the term law under Article 13 Clause 2 does not include Constitution amending law under Article 368. So in Shankari Prasad judgment, for the first time Supreme Court separated the concept of legislative powers of the government under Article 13 Clause 2 and the constituent power of the Parliament to amend the Constitution or change the Constitution under Article 368 of the Indian Constitution. Now this judgment became very critical as it in a way made the amendments made by Parliament under Article 368 beyond judicial review, as it was not considered law within Article 13 Clause 2. Further, the Supreme Court also held that Article 368 empowered Parliament to amend the Constitution without any exception, including fundamental right. So basically Supreme Court held that the Parliament had the power to amend the fundamental rights. Further, Supreme Court also agreed that fundamental rights can be amended and abrogated by Parliament if they follow the procedure which has been provided under Article 368 of the Indian Constitution. So this was a very important judgment which bifurcated the legislative powers of the Parliament under Article 13 Clause 2 and the constituent powers of the Parliament to amend the Constitution under Article 368. Now from Shankari Prasad, let's move to the another important judgment of Supreme Court in the case of Sajjan Singh, which was delivered in 1965. Now in this judgment, the constitutional validity of the 17th Constitution Amendment was challenged as it placed certain statutes or law under the 9th schedule. So basically under Constitution 17th Amendment, some of the state laws pertaining to property were placed under 9th schedule, and this overall impacted judicial review of the high courts under Article 226 of the Indian Constitution. Now it was in this case where the Supreme Court held that the pith and substance of Constitution 17th Amendment was to encourage agrarian reforms, and any impact on the curtailment of powers of the High Court under Article 226 was merely indirect, insignificant and only incidental. Now we have seen in the doctrine of pith and substance that the purpose of the judiciary is to find out the true nature or essence of the particular legislation without going into the impact of the legislation. So the Supreme Court used this doctrine in Sajjan Singh judgment and overall held that the pith and substance of the Constitution 17th Amendment was to encourage agrarian reforms, and any impact or any incidental impact which curtailed the powers of High Court was merely coincidental. Now another important aspect of the judgment was that the Supreme Court reiterated the relation between Article 13 and 368 as was established in the Shankari Prasad judgment. Now from Shankari Prasad, let's move to the another important judgment of Golaknath, which was delivered in 1967. Now this important judgment overruled both Shankari Prasad and Sajjan Singh, as it held that constitutional amendment is law under Article 13 of the Indian Constitution, and hence any constitutional amendment made by the Parliament would be subject to judicial review. It further highlighted two very important aspects. It held that fundamental rights under Part 3 cannot be amended by the Parliament, and also the fact that the term law under Article 13 also includes constitutional law, as Article 13(2) gives an exclusive definition of law. So again, the aspect of legislative power of the Parliament under Article 13 and the constituent power of the Parliament under Article 368 were merged, and overall any constitutional amendment became subject to judicial review. Now regarding Article 368, this judgment held that Article 368 did not confer amending power but had merely laid down the procedure for amendment. So it said that Article 368 did not provide for amendment as such, but only the procedure for amendment, and also held that the substantive power to amend the Constitution is not found under Article 368 of the Indian Constitution, and said that the term amend envisaged only minor modification to the Constitution but not any major alterations. So these were some of the very important highlights of the Golaknath judgment, whereby it overruled Shankari Prasad and Sajjan Singh, and also held that Article 368 merely provided for a procedure to amend the Constitution and not the amendment itself. Now after Golaknath, some of the important constitutional amendments took place, such as the Constitution 24th Amendment, which added Article 13 Clause 4, Constitution 25th Amendment, which added Article 31B and 31C. It also amended Article 31 dealing with compensation which could not be challenged in a court of law. Basically, judicial review was barred. 26th Amendment, which omitted Article 291 and 362 pertaining to the privy purses, and the 29th Amendment. Now this amendment added two Kerala Amendment Acts to the 9th schedule, and this overall led to the Kesav Nanda Bharti judgment. So in this backdrop, let's understand what was decided in the Kesav Nanda Bharti judgment, and also find out whether it overruled or not the previous three judgments. Now the Kesav Nanda Bharti judgment was decided by a 13-judge bench. Now the Supreme Court in its judgment gave certain important judgments with respect to Article 13, Article 368 of the Indian Constitution, and also established the principle known as the basic structure principle. Now this judgment on certain instances have endorsed Shankari Prasad and Sajjan Singh, and on certain instances have overruled Golaknath. Let's see what this particular judgment has exactly provided. So this judgment highlights that the power to amend the Constitution is to be found in Article 368 itself. Now we have just discussed that the Golaknath judgment held that Article 368 did not confer amending power to the... So on this note, it overruled Golaknath. So the Supreme Court held that power to amend the Constitution is to be found in Article 368 itself, and emphasized that provisions relating to amendment of the Constitution are some of the most important features of any modern constitution. Another important aspect is that the court recognized the distinction between ordinary law and constitutional law. So on both these aspects, it endorsed the Shankari Prasad and Sajjan Singh judgment. And regarding the aspect of amending powers of the constitution, it overruled Golaknath judgment. Further, the court also held that the constitution makers did not use the expression law in Article 13 as including constitutional law. So basically, it meant that Article 368 confers power to abridge or amend either fundamental rights of the constitution or any part of the constitution. As the Supreme Court in case of Nanda Bharti judgment held that the constitution makers did not use the expression law in Article 13 as including constitutional law. So it basically separated the constituent power of the parliament from the legislative power of the parliament under Article 13 and 368. Now again on this aspect as well, the judgment of Golaknath was reversed or overruled. As according to the Golaknath judgment, fundamental rights under Part 3 could not have been amended. Now despite these aspects of the judgment, Supreme Court further held that Parliament, even though have the distinction of a constituent power and a legislative power, it does not have unlimited power to amend the constitution. And amending power cannot be exercised by Parliament in such a way to emasculate the basic or fundamental features of the constitution. So for the first time, the term basic or fundamental features of the constitution was used by the Supreme Court in the case of Nanda Bharti judgment. And the Supreme Court also held that the Parliament, in the guise of amending the constitution, cannot rewrite the constitution in a very different way. And it was here where the Supreme Court held that there are certain features of the constitution which cannot be amended. And these features include supremacy of the constitution, republican and democratic form of government, secular character of the constitution, separation of powers between legislature, executive and judiciary, and federal character of the constitution. So all these features were included as basic features recognized by the Supreme Court, which could not be amended by the Parliament. Now another important point to be noted is that fundamental rights can be amended by the Parliament unless it affects or impacts the basic structure of the Indian Constitution. The Supreme Court further held that the term amend has a very restrictive meaning and cannot include fundamental change in the Constitution, and in the guise of amending the Constitution, the Parliament cannot rewrite the Constitution in the name of amendment. Further, the court also said that they have the powers of judicial review even with respect to constitutional amendments made under Article 368 of the Indian Constitution. Thus, the Supreme Court said that the courts can inquire into whether or not an amendment destroys the basic features of the Constitution. So, if a constitutional amendment goes beyond the provisions of the Constitution, judiciary has the power to declare such amendment as constitutionally invalid. And lastly, another important point which you must remember is that the Minerva Wills judgment added judicial review as another part of the basic structure. So now, judicial review was also added as a part of basic structure, and hence this aspect cannot be amended by the Parliament. Now I have discussed the aspects of judicial review in detail. As you can see, number of questions has been asked by UPSC in the past in the mains examination. Now this particular question asked in 2019 read, Parliament's power to amend the constitution is a limited power and it cannot be enlarged into absolute power. In light of this statement, explain whether Parliament under Article 368 of the Constitution can destroy the basic structure of the Constitution by expanding its amending power. Further, in 2014, a question was asked stating, starting from inventing the basic structure doctrine, the judiciary has played a highly proactive role in ensuring that India develops into a thriving democracy. Now, in light of this statement, evaluate the role played by judicial activism in achieving the ideals of democracy. In 2013, another question asked was, Supreme Court of India keeps a check on arbitrary power of the Parliament in amending the Constitution, discuss critically. So we see number of questions being asked on the aspect of amending powers of the Parliament and also on the aspect of basic structure of the Indian Constitution, including the aspect of judicial review. So these three topics cumulatively becomes very important from our examination perspective. Now another question asked in 2019 was, from the resolution of contentious issues regarding distribution of legislative powers by the courts, principles of federal supremacy and harmonious construction have emerged. explain. Now, regarding doctrine of harmonious construction, it is said that it is considered as the thumb rule for the rule of interpretation of statutes or interpretation of law. So basically, under doctrine of harmonious construction, if there is a conflict between two laws or two statutes, basically if there is a conflict between a law made by a state government and a law made by the central government, then such law has to be interpreted in a harmonious manner or through harmonious construction. It signifies that in cases of inconsistencies, proper harmonization is to be done between the conflicting parts so that one part does not defeat the purpose of another part. So this is with respect to doctrine of harmonious construction. So we understand that this topic becomes very important from our examination perspective. And regarding our syllabus, this topic gets covered under GS paper 2, especially with respect to features of the Indian Constitution, and in the prelims question can be asked in the section of Indian Polity and Governance Constitution. So after understanding the important terms with respect to colorable legislation, pith and substance, and also about basic structure, let's go to the next article. The next news to be discussed appears on page number 15. The news highlights TAFE CMD Mallika Srinivasan to head PESB. So in this article, we need to know about the PESB or the Public Enterprises Selection Board. Now this news says that Mallika Srinivasan has been appointed as the chairperson of Public Enterprises Selection Board, and this is the first time a person from the private sector has been made head of the PESB, which is responsible for appointment of personnel in the post of chairman, CMD and functional directors in public sector enterprises. So a question can be asked in your prelims examination regarding Public Enterprises Selection Board. So this board is a high powered body and has been constituted through a government resolution. That is, it is an executive body and not a statutory body. Further, the objective of this organization is to evolve a sound managerial policy for the central public sector enterprises and also to advise government on appointments to their top management post. And its various functions includes providing policy for selection and placement of personnel in the post of chairman, managing director or chairman cum managing director level 1 and functional director level 2 in PSCs, that is public sector enterprises, as well as in any other post which may be prescribed by the central government. Further, they also advises the government on matters relating to appointment, confirmation or even extension of tenure and termination of services of the personnel of above mentioned levels, that is these posts. Further, the board also advises the government on the desired structure at the board level and also for senior management personnel for each PSC or group of public sector enterprises. Further, this organization also advises the government on a suitable performance appraisal system for both PSCs and the managerial personnel in such enterprises. Further, the board also helps to build a data bank containing data relating to the performance of PSCs and its various officers. It also advises the government in formulation or making of and enforcement of code of conduct and ethics for managerial personnel in public sector enterprises and also advises the government on evolving suitable training and development programs for management personnel in public sector enterprises. So these can be said to be some of the important functions with respect to Public Enterprises Selection Board. And since for the first time a person from the private sector has been made its chairman, hence this board becomes important and also a question can be asked in the prelims examination. Now based on our discussion, let's take up this particular practice question. It says, consider the following statements about Public Enterprises Selection Board. First, it is a statutory body constituted under Ministry of Home Affairs. No, this statement is incorrect as it is neither a statutory body since it has been constituted through government resolution and it functions under the Ministry of Personnel, Public Grievance and Pensions. Hence, both the aspect of statement 1 becomes incorrect as PESB has been formed through a government resolution and functions under the Ministry of Personnel, Public Grievance and Pension. Second, it evolves sound managerial policy for efficient function of central public sector enterprises. Now we have already gone through the functions of PESB and it also aims to evolve a sound managerial policy for the central public sector enterprises. So the second statement becomes correct. The third statement says that the chairman of PESB must be from central government services. No, this is incorrect, as we have just seen in this particular news that for the first time a person from the private sector has been appointed its chairperson or its chairman. So in this the question was which of the statements given above are correct. So here only the second option becomes correct. So the correct answer becomes D, that is 2 only. Now regarding the constitution of the board, this board comprises of a part-time or a full-time chairperson and 3 full-time members. So the chairperson can be either part-time or full-time, but the members has to be full-time. Now regarding the board, it says that the chairperson and members shall be persons who have had a long and distinguished career in management of public or private corporations or public administration and have a proven record of achievements, preferably in the field of personnel, finance, production, or marketing. So both the chairperson as well as the members can be people from the private institutions. As it highlights that the chairperson and members shall be persons who have had a long and distinguished career in management of public or private corporations. Now regarding the 3 full-time members of PESB, it says that they shall be a distinguished serving or former chief executive of a public sector or private sector or joint sector enterprises. Next, a member should be a distinguished person with experience in selection of top management personnel and a distinguished serving or former civil servant with experience in management of PSCs or in areas of finance, industry or economic affairs. So one of the members of PESB must be a civil servant having an experience in management of public sector enterprises or having an experience in the areas of finance, industry or economic affairs. Now this article becomes important primarily from the perspective of our prelims examination and gets covered under the aspect of polity and governance, especially with respect to organizations. With this discussion, let's move to the next article. The next news to be discussed appears on page number 9. It highlights that BIMSTEC meet skirts Myanmar violence. Jai Shankar take part in an online event. The event was 17th BIMSTEC ministerial meeting. And in the meeting, India's Foreign Affairs Minister promised BIMSTEC members to take it to new heights through cooperation in various fields. Now in this regard, this news highlights that crisis in Myanmar with respect to Rohingya refugees had stalled the progress on BIMSTEC Charter, which is supposed to be adopted at the 5th BIMSTEC meeting. Now developments also could not take place on the aspect of BIMSTEC Charter as the refugee crisis in Myanmar had created bitterness between Myanmar and Bangladesh, 2 key members of BIMSTEC. So despite the differences, BIMSTEC members will be looking forward to adopt the BIMSTEC Charter, which will bind the member states at the 5th BIMSTEC summit. So on this note, let's go through the important sectors in which initiatives have been taken under the BIMSTEC umbrella. These sectors include entrepreneurship, military exercises, ministerial conclave at India Mobile Congress, disaster management exercise, climate smart farming systems, training of BIMSTEC diplomats at Foreign Services Institute, and also initiative with respect to Center for Weather and Climate, as it is being hosted in India and is fully functional with the state-of-art facilities to provide early disaster warnings. Other initiatives which are underway includes finalization of the BIMSTEC master plan for transport connectivity, as it will improve connectivity and also integrate the people of the region. Further, it mentions about BIMSTEC coastal shipping agreement and the motor vehicles agreement. Further initiatives have been taken with respect to cooperation in combating international terrorism, transnational organized crime, and also illicit drug trafficking. Further, there is also a BIMSTEC Convention on Mutual Legal Assistance in Criminal Matters, which has also been finalized for signing at the 5th BIMSTEC Summit. Another area of cooperation is among diplomatic academies and training institutions of BIMSTEC member states, and also an agreement, that is Memorandum of Agreement for establishment of technology transfer facility in Colombo, have also been finalized to be signed at the next BIMSTEC Summit. Now based on our discussion, let's take up this particular practice question on BIMSTEC. It says that BIMSTEC in recent years have undertaken joint initiatives in which of the following sectors? Options are: first, entrepreneurship; second, military exercise; third, disaster management; fourth, climate smart farming system; and fifth, combating terrorism. So the question is, select the correct answer using the code given below. Now we have seen that joint initiatives have been taken in all of these following sectors. So here the correct answer becomes D, that is 1, 2, 3, 4 and 5. Now regarding BIMSTEC, you should also know certain basic facts with respect to the formation of BIMSTEC. Now BIMSTEC, that is Bay of Bengal Initiative for Multi-Sectoral Technical and Economic Cooperation, is a regional organization and comprises 7 members. These 7 members are Bangladesh, Bhutan, India, Nepal, Sri Lanka and Myanmar and Thailand. Now initially this economic bloc was formed with 4 member states. That is, the term was BIMSTEC, Bangladesh, India, Sri Lanka and Thailand Economic Cooperation. Later, Myanmar, Nepal and Bhutan were added. Myanmar was added in 1997, whereas Nepal and Bhutan were added at the 6th ministerial meeting in 2004 in Thailand. Now another important aspect which you must know about BIMSTEC is with respect to the Bangkok Declaration. It says that the sub-regional organization came into being on 6 June 1997 through the Bangkok Declaration. So the BIMSTEC, which is a regional grouping, constitutes a bridge between South and Southeast Asia and also represents a reinforcement of relations between these countries. And BIMSTEC has also established a platform for intra-regional cooperation between SAARC countries and ASEAN members. So these are some of the important information which you must know from your prelims perspective, as questions can be asked in your upcoming prelims examination with respect to BIMSTEC, as 5th BIMSTEC summit is going to take place soon. Now this article on BIMSTEC becomes important both from your prelims and mains perspective. In the prelims gets covered under current events of international importance, and in the mains gets covered under GS paper 2 with respect to India and its neighborhood relations and also regional and global groupings. Now after our today's discussion, this becomes your question for the day. The question is, consider the following statements. First, 4th BIMSTEC summit concluded with Kathmandu Declaration. Second, India and Myanmar were added later in the BIMSTEC grouping. So the question is, which of the statements given above are correct? Now coming to the answer of yesterday, the question was, which among the following accounts for the highest share of internal debt of the government? Options were treasury bills, dated securities, cash management bills and securities against National Small Savings Fund. In this, the correct answer is B, that is dated securities. So highlighting the summary for today's discussion, we discussed about doctrine of Pith and substance, doctrine of Colourable legislations and important Supreme Court judgments with respect to the doctrine of basic structure, including Sajjan Singh judgment, Shankari Prasad judgment, Golaknath judgment and the judgment provided by Supreme Court in the case of Nanda Bharti judgment. Then we understood about the Public Enterprises Selection Board, as it is a high-powered body constituted by the Government of India through a resolution. That is, it is not a statutory body and a body constituted through the executive order. Now this news becomes important because for the first time a person from the private sector has been made head of this particular organization. So in this regard, you need to know about the functions of this board and also the composition with respect to the Public Enterprises Selection Board. And finally, we discussed about the BIMSTEC 17th ministerial meet which took place yesterday. In this discussion, we went through various initiatives which have been taken jointly by BIMSTEC members and also certain basic facts with respect to BIMSTEC itself. So since the 5th BIMSTEC summit is about to take place, hence you need to know about BIMSTEC organization, as questions can be asked in your upcoming prelims examination. So with this question for the day, we come to an end to today's discussion. Thank you.